Well, hello everybody. This is Joel Williams with Williams Elleby, and I'm super excited today because I've got my good friend, an excellent attorney, Darl Champion of the Champion firm in Marietta, here today to talk to us about bringing claims against a government entity. I've been looking forward to this video for several weeks since Darl agreed to do it. I went to a little CLE that he put together at his firm last week. And I'm like, man, this is good stuff. We got to get you on the YouTube channel and talk to our viewers about that. But before we jump right into it, can you just tell us a little bit about yourself, like we say in a deposition, your education, your background, and what you do?
So I grew up in North Carolina, moved to Georgia to go to law school at Mercer. Kind of how I've gotten into government liability claims is I clerked for a federal judge for 2 years after law school. And so that allowed me to be exposed to a variety of different, mainly federal constitutional claims. And then after that clerkship, I spent 2 years working at a defense firm briefly before I switched to the plaintiff side. And at the defense firm, though, I worked on some government liability defense. And so I got really involved in reviewing the statutes, reviewing the case law on, state liability counties and cities, and sort of just kind of like developed an expertise in this, and then have been asked to speak at CLEs about it. And I've had this PowerPoint for a few years, and I've actually revised it a few times. And what I've done with it is I then took that, made it into an in-house CLE that we did, and then also gave it at a CLE at the state bar last week. So have definitely been repurposing it and just sharing my knowledge about this area of law, because it is very, very complicated.
Yeah, it's, to me, I've handled them before, but it's not the most common thing that happens, right? Like most of our cases, we're dealing with, our client versus another person or a private corporation or something like that. But it's a whole nother ballgame when you're dealing with suing any type of government entity.
It is.
We are obviously in the state of Georgia. Darl and I both practice primarily in Cobb County, all over the state, but our offices are in Cobb County. So just by that nature, most of our clients come from Cobb County. But in Georgia, it gets really convoluted, right? You got certain rules for claims against the state, you got certain rules for claims against the county, you got certain rules for claims against the city, and then any of those different departments within the counties and cities and state. So I, for the first time in a long time, got some notes so I can stay
I need some
on
too.
track.
I thought about writing on my hand all the different things, because it is very complicated.
That's exactly right. So, generally, at least in Georgia, why is it so convoluted when you need to file a claim against a government agency?
So the reason is really simple, and there is no uniform law that applies to all the levels of government. There's one set of rules for the state, there's a set of rules for the city, and there's a set of rules for the county. And it's not all in statutes. It's not all codified in a statute where you can go look and say, okay, this statute says X, Y, and Z, this is what I must do. It's this weird combination of statutes and case law that has existed for decades, and there's inconsistencies, there's things that don't really make logical sense. And so it can really lead a lot of lawyers who are good lawyers who routinely handle cases to maybe even make mistakes in this area. And it really is a minefield. And so, unless and until Georgia gets a uniform Tort Claims Act where it's the same at every level, it's going to continue to be very, very complicated.
Yeah, I guess that's so for those of us that aren't familiar with it, a statute is just a law that's passed by the legislature in the state or federal government and signed into law by the governor or the president. Case law are opinions in individual cases that judges have handed down throughout the years of appellate courts. And those laws mesh together and control what we have to operate under as practicing attorneys. So you can imagine how convoluted it gets when the people that are writing the laws are the government, and they're telling you how and when and then what procedure you have to use to sue the government entity that they operate. So let's try to break it down a little bit from state to county to city. So let's start with the state. Are there statutes and regulations, or what are they that govern when you need to bring a claim against the state of Georgia?
Sure. So The state of Georgia has something called a State Tort Claims Act, and among all the levels of government in Georgia, this one is by far the most detailed.
Yeah.
It's the most detailed in terms of the procedural requirements before the lawsuit's filed, the scope of the waiver, the exceptions to the waiver, just everything. A lot of stuff is in the statute. When you get to city and county, it's not as detailed. So with the State Tort Claims Act, it has, for example, a presentment requirement, which is called an ante litem notice, meaning before litigation, you must send a notice to the governmental entity involved and provide certain information. And the statute's very clear on what must be provided, where it must be sent, the method that must be used to send it. The deadline is 12 months from the date of the incident, and there's really nothing that extends it. It's not like a statute of limitations where, for example, like a traffic citation may extend it. And I'll tell you what I do personally. I've handled a lot of State Tort Claims Act cases. I have the form that I use, and every time I have to send a notice, I still pull up the statute and walk through and just mark it off in my mind, not only to make sure the statute hasn't changed, but just to make sure that I'm not missing something, because it is very detailed. And if you leave out a piece of information in that notice and go and try and sue the state later, your case could get dismissed. And that can be a really big problem. One of the most important things to know, aside from the deadline for sending the ante litem notice, is there is a limit on what you can recover from the state. So it's $1 million per occurrence. So if you have somebody who was, let's say, killed in just a routine car wreck with a state employee, the most one person could get is $1 million. The state's aggregate liability, meaning their entire responsibility for that whole accident, let's say multiple people died or were injured, is $3 million. So this isn't like if you were suing, for example, Coca-Cola or Home Depot. The sky's the limit in terms of what the damages are that you can recover. Same thing with a private individual. You can get unlimited damages awarded. Now, there may be a separate issue as to whether you can collect. But at the state of Georgia, that's the cap. That's all the judgment can be.
Yeah, so it doesn't matter whether you have a claim that's, maybe somebody breaks a finger or somebody's a quadriplegic the rest of their life. You're never getting more than that $1 million per person or $3 million per aggregate.
Exactly. And so there is one kind of narrow area where maybe those limits aren't going to be all that you can recover. So if it's a state law claim, you can't sue the individual employee. You're just barred from it. You can only sue the state. But if you have, let's say, a federal constitutional claim, let's say that the misconduct rises to that level. Maybe it's an excessive force case in a prison or outside of a prison, or it's a deliberate indifference claim involving medical care. You can sue the individual employee for the federal claim, and they are not, now they have a separate type of immunity called qualified immunity, but there is no cap against them. So there could be issues with collectability though, and is the state going to pay for any judgment you get from them? But when it comes to state law claims, all you're getting is that $1 million per person. Yeah.
And you said something that's kind of interesting there too, because you mentioned immunity, right? To me, that is the single biggest difference between bringing a claim against a private individual and a government entity, because basically my understanding of it, and I know it's more detailed than this, but this is the Joel Williams version of it, right? So the state of Georgia says, we're immune, period. Like, you can't sue us, except under these, how many exceptions are there?
There's, gosh, I mean, it's like 13 or 14.
Yeah, it's like you can't sue us except here.
Yeah. And that gets complicated in and of itself. A lot of the ones that apply to tort claims, which, a tort is just the personal injury claim, those are things like assault and battery. There's an assault and battery exclusion, for example. There's a law enforcement functions exception to the waiver. So there's immunity, then there's a waiver, and then there's exceptions to the waiver. Exactly. So it's very confusing when you dig into it, and that's why it's important for anybody handling a case, whether it's a lawyer or they're handling it on their own, to really do their research, because you don't want to spin your wheels and get into a case and find out, a year or two into it, that there just isn't a viable claim, and there's literally nothing you can do about it. And we hear from clients, they say, well, this isn't right, they did X, Y, and Z, and it doesn't matter.
That's we agree, it's not right, but that's the way. We didn't write the laws, but if you don't hear anything else we say today, I mean, absolutely 100% of the time, if you're hurt or injured by the state, a county, a city, any of those different entities, you absolutely need to get a lawyer. And I'll tell you right now, like, if I pulled out of here and got hit by a Department of Corrections bus, I'm not representing myself. And I'm a lawyer. I've represented other people doing it, but I'm not doing it. Like, I'm calling Darl to help me out with that case, because there's too many landmines that you can fall into, and if you mess up one of them, you're done. Like, it's over. So go ahead.
I was gonna say, I think the important thing for people watching this video to understand too is the urgency. Yeah. Because when you're dealing with, let's say, you just get rear-ended by a private citizen on Cobb Parkway, there's a 2-year time limit to either settle your case or file a lawsuit. When you're dealing with these ante-litem requirements, those are shorter. Yeah. It's 12 months for the state, but it's 6 months for the city, and I know we'll get to that, but that comes up quick. And if you're waiting until the last minute to start calling around to a lawyer, the lawyer may not want to touch it because they're like, I'm worried I'm going to get sued for malpractice.
Yeah. You need time to properly investigate the case.
Exactly.
Do all those things. It reminds me, because we handle, I know you handle med mal too, but we handle a few med mal cases. And every time that we bring on a new med mal case, there's certain statutes that are very detailed that you have to follow. There's certain requirements for experts and that kind of thing. I could probably recite most of those statutes to you, not word for word, but I know what they say. I still go back and read them every single time because I'm overly anal and worried that something changes. Yeah, absolutely. Because I know, like, there's certain things in those cases, if they're not done correctly, it's a fatal flaw, and that case is done. I'm going to be on the phone with my malpractice carrier, which I don't ever want to have to do.
Exactly.
So let's talk about cities for a little bit.
Sure.
What are some of the differences, say, if I needed to sue the city of Marietta versus I'm suing, the state of Georgia?
So the cities, they don't have a tort claims act similar to the state, but what they do have is a variety of statutes that talk about the procedural requirements, some that talk about immunities, and then there's just a large body of case law that talks about, one, interpreting these statutes, but two, creating some exceptions to them and talking about what us lawyers call the common law. So, essentially the judges that, created certain exceptions and certain doctrines before statutes may have been passed on that issue. So with cities, the most important thing to know is that ante-litem notice requirement is 6 months. And again, that sneaks up quickly. Yeah. The ante-litem notice must state the time, the place, the extent of injury, the nature of the injury, and describe the negligence that caused the injury. But one requirement that gets a lot of people in trouble is it must state the specific amount of the loss claimed. Yeah. And it's got to be precise. It can't be we are seeking damages up to or in excess of or in the range of. It must say we are seeking X. Yeah. We are seeking $500,000 or $1 million. So that's the procedural requirement. That ante-litem notice must be sent to the mayor or the chairperson of the city council. Yeah, and I think I haven't done some scientific study on this, but just reading case law that's come down over the past few years on this. That specificity requirement and amount is probably the single area that has gotten most attorneys in trouble. Not in trouble, but where they've made a mistake. Yeah. Because we're so used to sending demands that say, our client has $200,000 in medical bills. We intend to demand $5 million or whatever the amount is that's appropriate for that case. But you can't just do that. You have to say, okay, City of Marietta, we're demanding $500,000. Yep, it's got to be very specific. And then the other thing that you need to know, and this relates to the amount, is there isn't unlimited damages. There isn't a hard fixed amount, but cities waive sovereign immunity to the extent they have insurance that covers that particular act or negligence that caused the injury. So, for example, let's say that somebody slips and falls at City Hall. if they have $1 million policy that covers it, let's say the city of Marietta has that policy, that sovereign immunity will be waived up to $1 million. Now, for motor vehicle accidents, there is an automatic waiver for cities and counties of $500,000 per occurrence. I think it's $700,000 aggregate for the whole incident. But that is an automatic waiver that exists for motor vehicle claims. So the good news is, let's say that you have a city, and this was the law before the automatic waiver, you can just say as the city, I'm not buying insurance. And can't do anything about it. You know, we have sovereign immunity. So
You better hope you have UM coverage.
you better hope you have good uninsured motorist coverage, yeah.
See previous videos.
Yeah, see Joel's previous video on UM coverage. That's very important. But even now with this, it's very important because let's say that you have a city that has the $500,000 limit, or it could even be $1 million. I mean, if it's a serious injury or a fatality, you may need to use that UM coverage. So when dealing with cities, the other important thing to know, and this is where they differ from counties as well, there's a waiver for what's called a ministerial function for cities. There's also a waiver for nuisances. That's different than counties. So with a city, if something is considered a ministerial function, they've waived sovereign immunity. And there's this whole body of case law that talks about obligations that the city has that are imposed on it by the legislature. Those qualify as ministerial functions. There's things like, I think even maintaining sidewalks is considered a ministerial function. So even if they don't have insurance.
Surprising to me.
That is surprising to me. You'd think it was a governmental function. But again, that's why it's like there's this combination of statutes and case law, and some of these cases have been around for over 100 years.
Yeah.
And once that case gets decided, it's hard to deviate from that, and that's just perpetually gets cited in other decisions, and it remains the law.
Yep. Okay, let's talk about counties because they are different than cities.
Yeah, so this one is a real head scratcher for me. Counties only waive sovereign immunity to the extent they have insurance for motor vehicle claims, period. There is not, so cities have a broader waiver for insurance that covers anything. So I gave the example of the slip and fall at City Hall. If you slip, let's say at the county commissioner's office, even if they have insurance for that, you can't sue the county.
Your rights are entirely different just because of where you were at when it happened.
Exactly, and it makes zero sense. There's zero public policy reason for that. It's just the way that the law has evolved over years. And so you have this dichotomy that depends on, did I get injured in the city or did I get injured in on county property? Was it a city official or a county official that injured me? So that's probably the biggest difference. There is still the automatic waiver we talked about for cities for motor vehicle claims. That applies to counties as well. So if a county doesn't have car insurance, you still can get up to $500,000 automatically, assuming your damages are there. But there is not a waiver, the broader waiver for insurance. There's no waiver for ministerial functions, and there's no waiver for the nuisances. So that is, the biggest difference. The other difference is the presentment requirement. So with the city, you have 6 months to send an annual item notice. With counties, you have 12 months. Well, the statute is super vague about where do you send it to, what must it say. So you have to look at cases that have interpreted that. The other interesting thing about the counties is there's cases that say your lawsuit, if filed and properly served within that 12-month period, can meet that notice requirement. Yeah. So that's another area where it's a little different, but that's probably the biggest example of where it's just really complicated. And I've seen lawyers, get confused on that and think that they have a claim against the county because they have insurance.
Yep. That the ante litem. As if that's not complicated enough, we have to call it something using Latin words, right?
Exactly.
I mean, come on.
I think I made a D in Latin at this
point. I may or may not have had some words on the back of my hand. If Miss Alderman's watching, I deny it to this day. No, but so when you're doing a county claim, I know that it's just one of those things where, yes, your lawsuit can be the first notice, and I know that's what the law says. But I can't make myself let that be. Unless it's like the client calls me at month 11, like I have to go ahead and send it.
So here's where it could come up. Let's say that it's determined that the prior notice was deficient.
Right.
Maybe you sent it and the paralegal just didn't do something correctly that you thought, or let's say you screwed something up. Don't want to throw the paralegals under the bus.
It all comes back on us.
It all comes back on us. But like, sometimes though, like when we as lawyers, we draft something and we give it to staff to send out, and it's out of sight, out of mind. And let's say that we said, send this a certain way and it doesn't, or it gets misaddressed or whatever. I mean, it happens. I mean, and I've made mistakes too. But if you go and look, back and say, oh man, we're in litigation and I filed this, but gosh, it turns out this notice was deficient. As long as you filed the suit and served it within that 12-month period, you're good. Now that doesn't apply to the state and the cities. You make a mistake on that, like that's it. If you've filed the lawsuit after making the mistake and you didn't send it right, your case is getting booted.
Yeah, and our appellate courts have zero pity on that. They may have pity, but they're like, nope, the statute says this, so that's what we're going with.
Yep.
Here's something interesting that I found that I don't think I really knew a lot about during your CLE. I've always looked at a sheriff as a county official. Mm-hmm. Apparently,
there's good reason for that.
Everybody doesn't look at a sheriff as a county official, especially the sheriff.
Yeah, so it's really confusing. So the Georgia Constitution says that the sheriff is a constitutional officer of the county. There's cases that have said that, well, that describes the territorial level of their jurisdiction or the level of government they operate in. But the county funds their budget. If you look at their W-2, of the deputies, it says Board of Commissioners. And in fact, all the cases say that the sheriff is entitled to the county's sovereign immunity. Well, if the sheriff isn't the county, then why is he entitled to their sovereign immunity?
Yeah.
The cases also say that you have to satisfy the presentment requirement for counties when suing the sheriff. Well, again, how can the sheriff be the county for purposes over here, but when you go to sue the sheriff, the cases say if the sheriff did something wrong, you can't sue the county.
Yeah.
You have to sue the sheriff in his official capacity. But you want to know where it gets really confusing, Joel?
I'm already confused.
So this makes my brain explode. So when you have what's called an official capacity claim, that is the equivalent of suing the governmental entity that employs the government official. Mm-hmm. Okay? So the cases say you have to sue the sheriff in his official capacity. There are cases, especially at the federal level, that say suing the sheriff in his official capacity is the equivalent of suing the county.
Right.
So if you sue, there's actually cases where, and I clerked for a federal judge for 2 years, and we did this all the time. When somebody would file suit against the sheriff in his official capacity and the county, the sheriff's official capacity claim always got booted because it was superfluous. Mm-hmm. And in fact, it was often the same attorney that represented both the sheriff and the county who would say, why are you suing the sheriff in his official capacity? You've sued the county. But then you have these other cases over here where they're like, nah, they're different. You got to sue them separately. And so it's super confusing. And that's also where people get in trouble is you have to send the any litem notice to the sheriff or the presentment notice to the sheriff.
Yeah.
Even though, like, if you went and looked at a statute, and let's say you were just new to this area of law, hey, I want to go see what do I have to do when I'm suing a sheriff. You're not going to find a single statute that says you must send a notice to the sheriff.
Yeah.
All that there is it says counties. It'd only be if you started researching case law that you'd see, oh, cases have said that this applies, and there's zero basis for it. It's just a judge said it, and well, that is a basis for it, right? I say there's zero basis for it, but in terms of a rational basis for it.
There you go.
And hopefully no judges that have written those opinions are watching your show.
They're probably past the Rainbow Bridge by now, 'cause a lot of those cases are so old. But yeah, and then there's also the issue of, like, we're talking about the sheriff, but sometimes you may be in a position where you need to sue an individual government employee. Mm-hmm. Or what situations can you do that versus the situations where I think we talked about some of the places you can't, but
sure.
Like, when is it appropriate to sue the individual employee?
Sure. So let me start by talking about the levels of government. So for a state law claim, you can never sue the individual.
Yeah.
Unless they were not acting in the scope of their duties. If they were off duty, well then obviously they're just like any private person. When you're dealing with the city and the county, you can never sue the government official for a motor vehicle claim. Well, that's what the statute says. Now, I think there's a debate about whether that statute is constitutional in terms of extending them immunity, but it would not be wise to challenge it, right? I mean, the only way anybody's ever going to challenge it is if they mess up and accidentally sue the employee and not the governmental entity, but you can't sue them for motor vehicle claims. You can sue city and county government employees for non-motor vehicle state law claims, okay? So let's say that you have the slip and fall at City Hall or at the county. County may be a better example because you're not going to be able to sue the county. Maybe you can claim that somebody violated a ministerial duty in the way that they set up the area. Maybe they didn't put wet floor signs out and they were specifically told by a supervisor, put a wet floor sign out.
Yeah, and again,
that could trigger what's called a ministerial duty.
Right, and again, that ministerial duty is something that essentially the employee does not have discretion on how they do it.
Exactly.
Like, it has to be 1, 2, 3, done.
And it's important, we talked about ministerial function for purposes of cities. That's separate.
Yeah.
Ministerial functions for cities are separate when analyzing ministerial duties for employees. So you can sue individual employees of cities and counties for non-motor vehicle claims for either violation of a ministerial duty or an intentional act. So that could be an assault and battery or something like that. You could also sue state, city, or county employees for federal constitutional claims. So this commonly comes up in, like, let's say a wrongful arrest or an excessive force case. They have what's called qualified immunity. So it's not absolute, it's qualified. And what you have to do to show a waiver of the qualified immunity and that you can sue them is a violation of a constitutional right. So that's number one. And number two, you have to establish that the constitutional right was clearly established. And that's the source of a lot of litigation, because defendants will frequently say, well, maybe I violated their constitutional rights, but it wasn't clearly established that my
Maybe
conduct...
I didn't, right? Because we don't even know if that's really clearly
Exactly.
established.
So, I call it, it's like the equivalent of the first bite rule, almost, that we see in dog bite cases, where if there's not like case law on point that says this conduct is unconstitutional, we'll frequently hear that argument from defendants. Well, there's no case that says that what I specifically did under this exact fact scenario is unconstitutional.
Yeah. It really blows my mind. So, I imagine if I'm confused with some of this stuff, like normal people that haven't been doing this as long as we have, or that are just trying to figure it out, are probably thoroughly confused by this point. So here's what I'd like to say in closing. These laws that we're going over so far today, that we've gone over today, are likely to vary significantly from state to state. So regardless of whether you're in Georgia or New York or Oregon or Oklahoma or Texas or wherever, if you've been injured or have a claim against, believe you have a claim against any government entity, contact a lawyer in your state that knows of as much about this area of law as Darl does in the state of Georgia, because just any lawyer is not going to do it, because you and I have both seen mistakes that have been made, and sometimes it's not even a mistake that's made because somebody's not a good lawyer or not smart enough. It's just they've never done it before, and so there's that one case out there that says this that they're not aware of, and they skip one step and the case is done. So the overall arching principle here is, if you've got to sue the state, if you've got to sue a county, if you've got to sue a city, if you've got to sue a government employee, make sure that you interview enough lawyers to find somebody who knows what they're doing, and don't fall into that trap of just calling the first commercial or billboard lawyer you see, because maybe they do know about these laws, maybe they don't. But do the interviews and ask the tough questions and probe that lawyer's knowledge of the subject matter, because it's going to be important to find someone who knows what they're doing in these type of cases. So in Georgia, I would highly recommend Darl for any government claims you have. You can call us too. We do it. I don't know, if I had a case, I'd call Darl. So, but feel free to call us on those cases, or Darl. But if you want to get in touch with Darl, can you tell everybody the easiest way to find you?
Sure. The easiest way is just go to our website. It's thechampionfirm.com. We have our phone number, contact form, and chat available on there.
Awesome. And y'all got social media and all that good stuff too,
Facebook, right? Instagrams, yeah.
Yes. So follow along.
Maybe TikTok at some point. I haven't really gotten into that trend yet.
If you get TikTok, I'm going to be the first subscriber. I can't wait to see you do something silly. No, but we really appreciate you spending time with us today, and thank you.
Thanks for having me.
Darl. I appreciate you coming on. So thank you so much for joining us today, and if this video has been helpful to you, if you've learned something like I have from what Darl has taught us today, give us a thumbs up on the video, give Darl a shout out in the comment section below, tell him you appreciate the information he's been able to give to us. If you have any questions, be sure and put those in the comment section. I should be able to answer most of them. If it's over my head, I'll get in touch with Darl and figure out the answer for you. But yeah, thanks for joining us, and we will see you next week for our next video.